All right, be seated. All right, we're here on a motion for bond reduction on State of Florida versus Michael Drejka. It's case number 1809-851. Here for the state is Mr. Schaub and Mr. Rosenwasser. Here for the defense is Mr. Trevino, Mr. Camarano, and Ms. Clifton. Are we ready to go?
Yes, Your Honor, we are.
All right, what says the defense?
Your Honor, Mr. Drejka is 48 years of age. He has been in Florida approximately 10 years, Your Honor, so he's been a long-time resident. He has substantial ties to the community. He's been married approximately 8 years, but in fact, it is 8 years. This Saturday is his anniversary. He has absolutely no prior criminal record whatsoever. He has he's originally from Delaware. His father is a retired Delaware state trooper. His mother is deceased. He's been a concealed weapons permit holder for many years, and he has had firearms training in the past. He has had some financial problems, Judge, that necessitate the court's consideration of a very low bond in this matter, because anything significant he will simply not be able to make, Judge. He's not employed currently, and although his wife is employed full-time, she just simply doesn't make that kind of money that could afford that type of bond. They've been told that they have to vacate their home that they rent the end of this month. So in another 10 days, his wife and his 2 dogs are going to be homeless if we can't reach some resolution on this bond issue. A lot of people have been talking about crowdfunding. Oh, well, he's going to be able to get lots of money from this case because people will donate and so forth. That's completely incorrect, and these news articles talked about that are in error because simply no one will host a crowdfunding or fundraising page for Mr. Drejka. Given the nature of this case, it's just not simply something that would be successful. At least at this stage, no one has been able to see anything like that come to fruition. So it's not likely he's going to be able to get any funds through any kind of third-party crowdfunding or contributions. I would point out that I'm not going to reiterate the facts of this case, Judge. I'm sure the court has viewed the video before on the news, and as all of us have seen it. So I'm not going to talk about specifics other than to reiterate that there was only one shot involved. This is not a situation where the gun was emptied on the victim in the case. He stayed at the scene. But even more significantly, in addition to staying at the scene while the investigation was being conducted, he remained in Pinellas County, continued at his place of residence, and made no efforts to escape or leave the area while the entire investigation was pending for many weeks. So given that initiative on his own to stay and ultimately face whatever charges were going to be filed, demonstrates, Judge, thoroughly that he is not a flight risk in this case. We would ask the court to consider lowering the bond in this case to possibly $25,000 and suggest that that would be the high end of any ability for the family to try to make bond in this case. I don't know what the court's thoughts are about a GPS or ankle monitor. If it's imposed, he has no objection as long as, again, he can afford to do it. It's a question of finances, not a question of he doesn't want to be tracked or anything like that. He has no objection to that. So given the totality of the facts in this case, Judge, as we know them at this point, obviously there's been no formal discovery yet, and given the absolutely exemplary background of Mr. Drejka, I mean, this man has an absolutely clean history. There's been some news reports about some prior incidents. None of those are real, and in the defense's position, Judge, those are fictional accounts by probably publicity seekers in the community. There simply is no evidence of any prior issues with Mr. Drejka. And again, he's almost 50 years old. We certainly would have seen something in that 50 years if this man had some history of violence, some history of problems. And then finally, Judge, I think it's important to note that Mr. Drejka did not take to social media when he was initially questioned about the shooting by the sheriff's office, and there was all the attendant publicity as a result. He didn't go to social media. He doesn't even have Facebook, Twitter. The media has been astonished that he's kind of a ghost on the public record because there are no sites you can go to see about Mr. Drejka because he's lived a very quiet life. And he did not try to use any kind of social media platform or media. He hasn't given any interviews and doesn't intend to do so in the near future, Judge. Given that he had the ability with all the different political pushes for the NRA saying they would support him and so forth, he didn't adopt any of those individuals who came forth to say that they were in support of Mr. Drejka. He's remained quiet, and I think that speaks volumes about his character and that he's not trying to use this to get personal fame or fortune, Judge. He just simply wants to go on with his life with his family, and we would ask the court to give real consideration to a reduction in this case because of the financial circumstances and the other things.
All right, thank you, Mr. Trevino. What says the state?
Your Honor, Mr. Schaub and I are going to divide up the arguments. First, I'll let the court know that there are some family members and friends that are here. Monica Moore Robinson, Mr. McLaughlin, some others present. Brittany Jacobs, his girlfriend, is present. Michael McLaughlin is his father. He's not present today, unfortunately, he couldn't be here. But there are extended family and friends that are here. They do not wish to make a formal statement to the court. However, they want me to express to you that they adamantly are asking that you do not reduce the defendant's bond. With respect to the defendant's bond motion, as the court knows, there is a bond schedule that's set up in Pinellas County. And the bond schedule basically has a range, a low range and a high range, within which certain crimes that are charged should fall within it. Certainly, a court can go above that range if the court wants to, below, but the state would say that there's a presumptively reasonable range. And I have a copy of the bond schedule if the court needs it. For this crime, this is a first-degree felony, the defendant is looking at 30 years in prison. The range is $10,000 to $100,000. The defendant's bond in this case is, in fact, $100,000. As the court knows, there's typically two ways that a bond can be set. One, at the jail by a booking officer, doesn't have any legal background or legal training, or a judge can say, in this case, Your Honor, this court set that bond based on a very detailed affidavit. And I'm sure the court weighed all the facts and circumstances that are in the motion, in the rules, in setting the reasonable bond. It's reasonable because not only is the defendant facing an extended period of time to 30 years, but our position is that the defendant shot an unarmed retreating person and killed him. Also, Mr. Schaub is going to address that the defendant does have a prior, not a record because he wasn't charged with them, but there's prior documented police reports of his activity in the community where he overreacts and draws a firearm. They're not made up fictional events. They're actually in police reports that occurred prior to the offense that we're talking about. In addition, the defendant made some statements during his interview that the court should be aware of during this hearing. And again, Mr. Schaub is going to be addressing those. The defense talked about the defendant being unable to afford the bond. I have a case that I'd like to present to the court, if I may approach, and to the defense counsel that just addresses that very, very briefly. It's a first district case. It's Dyson, D-Y-S-O-N, v. Campbell, 921 Southern 2nd, 692. And what this case states is that the fact a defendant cannot afford a particular bail or bond amount doesn't mean that the bail or bond amount is unreasonable. The court has to take into consideration numerous factors which are in the rules, and I'm sure the court will do that. And in addition to those factors, the court does take into consideration his financial condition. But again, just because he can't afford it doesn't mean the bond is unreasonable. I want to address what was in the defendant's motion to reduce bond, particularly paragraph number 3. And I think that we need to talk about it because it's in their motion. And what the defense stated is that the sheriff stated that the defendant was in fear of his life and that stand your ground applied. And I want to make this very clear for the court and for defense counsel because we're going to be filing motions about this. The sheriff's personal opinion about what he believes happened in this case isn't relevant. It shouldn't be considered by any court, shouldn't be considered by Your Honor at any stage of this proceeding. whether it's a stand your ground motion, a trial, whatever it is, it's his personal opinion. More importantly, I think, not only is it his personal opinion, and again, I'm only bringing this up because it's in the defendant's motion, they're relying on his press conference. And his press conference really had some information that was incomplete and some that was inaccurate. And I want to talk about a couple of those. And I have a video. It's a video of the shooting. If the court would like, I would certainly play it. I know it's been on the news to corroborate what I'm saying. For example, the sheriff, when he was giving his press conference, said that Mr. McLaughlin was just a few feet away from the defendant at the time of the shooting. And that's just simply not the facts of the case. There is a video, and the video clearly shows that they were more than just a few feet away. And there can be an argument that just a few feet could be 3 feet. There's no particular number that was mentioned during the press conference, but it was certainly more than just a few feet away. That's based on the video. It's also based on measurements that were taken at the scene that demonstrate that. Let's say someone was to argue that the video, because it's in a different location, that the angle shows something that's inaccurate. The defense, I don't think they have discovery yet. They don't have a copy of all the reports, the autopsy report, things of that nature. But the defendant himself in this case demonstrated to the detectives that he was more than a few feet away. The defendant's own words. So there's a videotape and an audio tape of this interview. It's in a 10 by 10 room. And the defendant is almost against the wall. And he's kind of demonstrating to the detective where Mr. McLaughlin was. And he keeps pushing him back and pushing him back. So he's almost 10 feet or more away. So the defendant's own statement is that he was more than just a few feet away. So if you rely on that, which the defense is doing in their motion, they're relying on inaccurate information. What also wasn't mentioned during that press conference is that Mr. McLaughlin was actually retreating at the time that he was shot. And if it's okay with the court, I'd like to show the video where you can clearly see that when the defendant brings out the firearm, there's an eyewitness outside and Mr. McLaughlin. And they both simultaneously recognize that this defendant is taking out his firearm. And they both simultaneously start to retreat. And what you can see in the video is that when the defendant gets the firearm, Mr. McLaughlin takes steps back. He's retreating. And he takes 3 steps back. And he's going back towards the car. And he can't retreat any further backwards because the car is blocking him. So he then turns to his right, and he's actually sideways, and his center mass is now facing out away from the defendant. And he's going back to the store where his son is. So Mr. McLaughlin is actually at maximum retreat when the defendant shoots and kills him. If it's okay with the court, may I play the video?
You may.
And this picks up right when Mr. McLaughlin goes outside and just before he pushes the defendant. You'll see right about here, Mr. McLaughlin and the witness recognize it. Now they're moving. 1, 2, 3 steps back. He's at the car. He turns to his right. The only thing that's facing the defendant at that time is Mr. McLaughlin's face, because he recognizes that he has a firearm and he's retreating. Which leads to the second point about the press conference. At the press conference, the sheriff pointed to the center of his chest, indicating that's where Mr. McLaughlin was shot, which would give the impression, if you take it together, that he was a few feet away, shot center chest, and that the angle then would be front to back. However, at the time, the sheriff didn't have the entire autopsy report. There are photographs, and what the photographs demonstrate is consistent with the video, that Mr. McLaughlin was in fact retreating. And I'm going to show the court photographs. I'll give a copy to the defense counsel. The bullet actually enters more towards Mr. McLaughlin's left side, and then it travels, and it actually doesn't exit, and it's underneath his right armpit. So that shows that if the court was the defendant, that he's at an angle away, which is consistent with the video, and that he wasn't a threat at all to the defendant. I'm going to approach, if it's okay with Your Honor,
You may.
and I'm going to give the defense a copy, and they're going to get this in discovery. And this shows the entrance wound. There's a cleaned up picture of the entrance wound. a bruise underneath the right armpit, and then there's an x-ray here that shows the bullet and where it remained.
All right, are you moving these into evidence?
If there's no objection from the defense, the state would move them into evidence for this hearing.
No objection for the purposes of this hearing.
All right, do you want me to seal these?
Yes, please.
Yes, sir.
Seal them until, I think discovery is going out to them probably next week. We're making the copies and everything as we speak. Once it's discovered, it would be open.
Right, I mean, as far as it being in the court file right now, do you want me to seal it while it's in the court file or not?
No, Your Honor.
Okay. Defense?
No, Your Honor.
All right, so they're admitted.
The other piece of information that's important is during this press conference, again, the defense cites this in their motion, the sheriff indicated that the defendant was in fear, and that's part of their motion. They put the language in there, and a stand your ground applied. And first I want to point out, because I read in certain places that people thought the defendant was feeble or something like that. If you look at the defendant's own booking photo, which I have if anyone wants to take a look at it, if the court wants to view it, the defendant's 5'10", 175 pounds. Mr. McLaughlin was just 3 inches taller, not that much of a difference. Prior to the defendant not working, how he was employed was he was someone that cut trees around power lines. So he was doing a very physical job. So it's not as if we have people that are very different in capabilities. When the sheriff spoke, he did talk about the law, but I do want to briefly address it, and the court knows this. In order for stand your ground to apply, and I'm going to read directly from it, deadly force is justifiable if that person reasonably believes, and that's the important part, reasonably believes that using such force is necessary to prevent imminent death. Like it's going to happen, imminent death or great bodily harm. The self-defense instruction states the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that danger could be avoided only through that use of force. Simply saying, well, I was in fear, doesn't make it so. It's got to be a reasonable belief. So if anyone says, well, he's waving the flag and stand your ground, that's not exactly what the law is. It has to be a reasonable belief. When you look at the video and the other evidence, it's clear that Marquise McLaughlin was retreating at the time that he was shot. And when you look at the video, the only person out there that's armed with a deadly weapon is the defendant. Everybody else is retreating. So there is no reasonable belief that there's going to be imminent death or great bodily injury. The defendant's own statement, again, the defense counsel doesn't have discovery yet, he's asked in his interview by the detectives, if Mr. McLaughlin, I'm going to paraphrase it a little bit, if he was standing still, would you have shot him? If he was moving backwards, would you have shot him? In other words, they're asking him, if he was standing still or moving backwards, would it have been a lawful shoot? And the defendant's response in this video and audio taped interview is no, it wouldn't have been a lawful shoot. And the evidence is he was moving backwards and retreating. So the defendant's own words, it's not a lawful shoot. So this is not a self-defense case in any way, shape, or form. So if anything, the defense shouldn't rely on what anyone's personal opinion is. They can rely on what the defendant said and what the evidence shows. As for the other arguments, Mr. Shaw is going to address those.
Your Honor, I'd like to talk about the prior incidents a little bit. It was brought out that he had been harmless during the time of his existence on this earth, and that's just not true. In 2011, the defendant received a carrying concealed weapons permit. He was schooled on that in Palm Harbor, Florida, and he received his concealed weapons permit. In 2012, January of 2012, a documented police report. So this isn't an incident where people want fame. This was an incident, unless they can predict the future. This is an incident that 2 young boys, 18 years old, were driving in their cars. And they approached a traffic light, and rather than run through the traffic light, they stopped on a yellow. They stopped at the light on a yellow. The defendant became upset. The defendant became angry. The defendant had that carrying concealed weapons permit, and he showed those 2 18-year-old boys the firearm. He displayed that firearm improperly. That was reported by law enforcement. The defendant was interviewed. Law enforcement didn't believe the defendant's story. The 2 18-year-old boys did not want to pursue the case, did not want to prosecute the case. but that incident's out there. Later that same year, in December of 2012, the defendant again was driving his vehicle in Pinellas County. There were people driving a car through a school zone. And believe it or not, the defendant thought that they were driving too slow through a school zone. How do you drive too slow through a school zone is beyond me. But he felt they were. As a result of that, he became angry. He displayed his firearm again. He displayed it to the individuals. At that time, law enforcement officers were parked nearby. The lady in the car told them what had occurred, what had taken place. The officers stopped the defendant, confronted him. Sure enough, he had a holster on. He had his gun there. And when the officer approached, the first thing he did was hand that officer his carry concealed weapons permit. He thought that gave him the right to do whatever he wanted with that firearm. And why is that incident important? Because it shows that he's a danger. He's a danger to himself. He's a danger to the community. It shows that on that day, during that video, he wasn't acting in fear. He was acting in anger. And that's relevant. The third incident was in 2013. At that time, he was ticketed for brake stopping an individual. He was upset at a lady who was driving for whatever reason. She was, I believe, a 37-year-old lady. I'm sorry, 32-year-old lady. And she had a 7-year-old and 4-year-old in that car. He was upset. He didn't display a firearm, but he stopped on his brakes, quit, drive, stopped his brakes, drive, causing an accident. She went and ran her car into her. $8,000 worth of damage. He was cited for that. He told law enforcement he was, in fact, brake stopping her. That occurred in 2013. Then finally, we had an incident just months before this incident, just months, the same exact location at that Circle A convenience store. And at that time, the defendant decided that he was going to be, again, the parking monitor for Pinellas County. He approached a man, Richard Kelly, who had parked his vehicle. He was working at a store for Mr. Tyler at that time. It was a tanker-type truck that he had parked. And he parked that tanker truck in that handicapped spot, the same handicapped spot that Ms. Jacobs parked her car at. And I would just venture to say, if anybody looks closely at that handicapped spot, it's not a legal handicapped spot. It doesn't have its legal markings. And what's ironic about that, she may have parked illegally at the time, but guess who else parked illegally at the time? The defendant. He was parked in a spot that wasn't even designated as a parking spot. So he was monitoring the situation at that time. He felt the need to monitor the situation when he himself was parking violations. But on that incident just prior to this, he approached the tanker truck driver and started arguing with him. That argument became heated. He used racial slurs. It was a black male. He used racial slurs towards that driver of that vehicle. It became so heated that the owner of that business, that Circle A, came out and told them to stop it. Told Mr. Drejka to stop this argument. He had known Mr. Kelly for years. He had known Mr. Kelly since he was a young boy. Mr. Kelly lived in that neighborhood and come into that store. Mr. Kelly then got into his car and left. Prior to getting into his car and leaving, the defendant went to his car and went to the center console area of that car. Mr. Kelly never saw a firearm, but he did see him go and get something from that center console area. He then drove away. Mr. Kelly drove away in the company truck. Moments later, the defendant contacted the owner of that business, Mr. Tyler, and expressed his opinions on that employee and how he parked his vehicle. Tyler will tell you that he tried to reason with him and explain to him that he'll talk to him and those type of things. And the defendant stated at that time, I could have blown his head off. At that point in time, the business owner said to himself, well, I'm not going to talk any reason into this gentleman here. He himself.
Yeah, I must object to this lengthy hearsay rendition. This is, I think, beyond the parameters of a bond hearing, Judge, and this is Williams rule type evidence that hasn't been properly discovered. Obviously, we're in such early stages, Judge. I think this is going way beyond the parameters of a typical bond hearing.
All right, I'll overrule the objection.
This is a response to other incidents, and this isn't one that was created for fame. This is one that was reported right after it occurred.
So that fourth incident was reported?
He contacted that business owner and reported it to him. That business owner attempted to talk sense to him, and then finally ended the conversation and said, look, just call law enforcement, have them come talk to me. Because he knew it wasn't going to go anywhere and wasn't going to go any good. So that was that other incident. So all those incidents shows that, number one, he is a danger to himself. He's a danger to the community. And we're not asking for a punitive incarcerating him. But what we are asking for is that he is a danger. He has been a danger to himself. He is a danger. He has been a danger to others. He was confronted by the owner of that business who told him he had to stop that behavior. And he told the owner of that business, I know, I can't help myself. I keep getting myself in trouble. He recognized back then that he had an issue, that he had a problem. That man should not have had a gun. The other thing we'd like to point out, Your Honor, it was brought to the court's attention, the bond schedule and bond amounts. We ran bond amounts and bond schedules in Pinellas County. A DUI manslaughter case with a $200,000 bond.
Objection, Your Honor. This is improper comparison, one case to another. We don't know all the details in each of these cases because it's their court bonds.
All right, well, I'll let him go ahead and do it, and then I'll let you say what you want in rebuttal.
$365,000 in DUI manslaughter. And it should be pointed out that this case is a first-degree felony. This case, because the use of the firearm, is a manslaughter that goes up to a first-degree felony. $300,000 in DUI manslaughter. An attempted manslaughter. This victim's living. This victim's walking around to this planet. $500,000. And a $1 million DUI manslaughter bond that was set on Mr. James Ward. So all those cases show that this $100,000 bond, which is within the range of the court's discretion, the bond setting at $100,000 is more than fair. It should also be pointed out that he does not have ties to the community, sufficient ties to this community. It should be pointed out that since he was 37 years of age, he's been unemployed. He hasn't worked. That was his own doing, not because of health issues. He decided not to work. He retired at the age of 37. His wife has been supporting him. Mr. Trevina said that he will be homeless as a result of this. Well, no, the wife is still working. She has always been the breadwinner. If it's homeless, it's no fault of the fact that he's in custody. He doesn't have sufficient ties to this community. He hasn't had a job since he's been 37 years of age in this community. We haven't interviewed that landlord. The landlord is having him move out of that residence. He doesn't have a stable residence in this community. And it should be pointed out the landlord was in the process of moving him out prior to this incident. It had nothing to do with this incident. But those are indications that show that the defendant does not have sufficient ties to this community, that the defendant should remain in custody. This case is aggravating. We watched that video, and if you watch that video, you see a door to that store that's open. That was his 5-year-old son that saw that occur. And what we didn't see on that video is that when he went into that store, he fell to the ground at the feet of his 5-year-old son as a result of Mr. Baker's conduct. Now, if the defense wants to, they want to get him out of jail, next month we can set the stand your ground hearing and we can have an immunity hearing. The video is what it is. The video speaks for itself. Thank you, Your Honor.
All right. Any rebuttal?
Briefly, Your Honor, I find it interesting that Mr. Rosenwasser spent such a great deal of time trying to discredit our own sheriff's opinion in this community and by trying to argue that it was personal opinion. I think that's almost disingenuous. I mean, clearly it's the sheriff's professional opinion. He's the sheriff. He's the investigating law enforcement agency who's conducting the investigation into this death. he concluded that it was within the bookends of the stand your ground statute and refused to arrest the defendant. Clearly, that's significant and unprecedented. Something that the court should and hopefully will take into consideration. Mr. Schaub said that the defendant has no physical disabilities or issues, that trying to allege that he's basically the same size as Mr. McLaughlin, completely untrue. Mr. Drejka is much smaller, and that will come out, of course, during the course of this case. But not only much smaller, the reason he hasn't been working since age 36 or 37, according to Mr. Schaub, is he's physically disabled. He was working doing tree trimming and tree cutting, and because of his increasing age and all of the physical pressures of that type of occupation, cutting these huge trees, he was physically unable to continue that employment. Afterward, he worked as an Uber driver, so he clearly doesn't have the complete background he thinks he has. And he tried working as an Uber driver for a period of time. He did quite successfully, had great reviews, and nobody accused him of pointing guns at anyone. And despite his efforts to try to maintain employment through Uber, his vehicle, unfortunately, was unable to keep up with that job for him. So that's the only reason he stopped doing the Uber. But he has worked again since age 37. But the physical disabilities is what caused him to stop working, doing the tree trimming. And then we're getting into a lot of specifics here. It almost started to sound like a trial at this point. We're here at a bond hearing and talking about, is he a flight risk? Does he have ties to the community? And we're talking about now breaking the video down for the court. Well, I noticed they didn't mention the violent shove that the alleged victim did to Mr. Drejka just prior to the shooting. I think that that's something that any jury is going to have to consider in a future point in this case. And the pivot that you see on the video by Mr. McLaughlin pivoting away is not a retreat. And I think that both expert testimony and the factual evidence in this case will show there was no retreat by Mr. McLaughlin, certainly none perceived by my client. One shot, he terminated the threat after being violently shoved to the ground. You can try to put lipstick on a pig in this case, but the state's not going to be able to stop those facts from coming out. And given that, Judge, we again reiterate our request respectfully that the court consider lowering the bond to $25,000 to an amount that he can make. Thank you.
Thank you. Of course, the defendant in every criminal case is entitled to a reasonable bond under all the facts and circumstances in accordance with the factors enumerated in Rule 3.131 Florida Rules of Criminal Procedure. He isn't necessarily entitled to a bond he can make, but a reasonable bond under all of those factors. I was the one that did review the complaint in the case, and at the time that I did review that, I did find that there was probable cause. I did consider all of the facts that were alleged in the complaint, including potential mitigating circumstances, such as his lack of prior convictions. In the complaint itself, it did contain the allegations of those prior incidents, and those things may or may not be relevant in the future. They may or may not turn out to be true or not. Those are obviously issues for the future as far as their admissibility and the factual basis of those. Obviously, we're not here today for an immunity hearing, and we're not here today for a trial. We're here to determine what the proper bond would be, but I do look at all the information that I have. As the state did point out, there is a uniform bond schedule, and this is a first-degree felony, which means that it's punishable up to 30 years, and $100,000 is certainly within the parameters of the uniform bond schedule. Of course, the court could decide that it could be a lot higher than that. I set it at $100,000 because I felt that that was the appropriate amount under all of the facts and the circumstances. And it's interesting in regard to other first-degree felonies under the uniform bond schedule. There really aren't that many first-degree felonies in Florida statutes, and there are a number of those that don't even involve victim injury at all. For example, sales of cocaine within 1,000 feet of a park or a school or a church. There's Medicare fraud. There's communication fraud. There's a grand theft of over $100,000, a grand theft of over $50,000 if the victim is 65 years of age or older. So I would consider those cases, although serious, to obviously not be as serious as a charge as a manslaughter, because the thing about a manslaughter, of course, is that there is an alleged victim who is dead. And that is the only charge with a first-degree felony where there is allegedly a dead victim in the charge. And that also affects the score sheet. Now, the state can correct me if I'm wrong, but I think manslaughter is a level 7, so that's 56 points. Add 120 points for death. I think that comes to 132 times 0.75. So the bottom of the guidelines, if my math is correct, is 11 years, and the top is 30. So there's really no other first-degree felony that is like that, obviously. Someone does an act that's negligent and results in the death of an individual. And then there's manslaughter by act, where a person allegedly does an act intentionally that leads to the death of an individual. So even if you're just talking about the charges themselves regarding manslaughter, there's a pretty good argument that manslaughter by act would be more aggravating than even a manslaughter by culpable negligence. So I did take everything into account. As I said, I think there's arguably some mitigation here. There's arguably some aggravation, but as I originally concluded, I believe $100,000 is a fair and reasonable bond under all the facts and circumstances of the case in Rule 3.131, so I will deny the motion at this point. So I understand that we have an arraignment set on September 5. If the defense would like, you can waive the arraignment, because obviously nothing happens at an arraignment anyway. We can set a pretrial. I'll give you a couple choices. I can set the pretrial at the time that I usually set it, which is about 3 weeks after the arraignment, or if you want to waive speedy trial, we can set it down the road, obviously with the condition that you're going to start working on the case, because I don't see any reason why we can't do this expeditiously here, which means as soon as practical, with everyone getting due process, including the state and the victim's family and the defense. I don't think there's any reason for it to unduly drag on. If you would like an immunity hearing at some point, obviously you're entitled to that. I think it's probably a good idea if we call it what it is. It's not really a stand your ground hearing. I know that some people like to call it that. It's an immunity hearing, and the defense itself is justifiable use of deadly force, also known as the self-defense. I don't know why we call it a stand your ground defense, but we do. So since we're all lawyers, we should probably call it the right thing. An immunity hearing is an immunity hearing, and the defense that the defense would be asserting would be justifiable use of deadly force. also known as self-defense. So there's one line in the statutes about stand your ground where it says that a defendant does not have a duty to retreat and has the right to stand his ground. And for some reason, based upon that one line, we call it a stand your ground statute and a stand your ground hearing and a stand your ground defense. I mean, it's really not. So I don't know if people are going to stop calling it that, but it would be nice if the lawyers call things what they are. I don't think there's any objection from any of the lawyers for that. So, Mr. Trevino, would you like to waive the arraignment? Would you like to waive speedy trial and have it set down the road? I don't know if you're going to need to talk to Judge Rondolino on the J calendar about costs. I don't know what your situation is.
That's one of the things we're working on, Judge, yes.
All right.
We would like to waive arraignment, Judge, and we would like to waive speedy trial and have a pre-trial set sometime far off that the court is comfortable with so that we can prepare our next step.
All right. And that's probably in everyone's best interest, because if we have hearings in between where we're just going to continue things, it may be an uncomfortable and inconvenience thing for the families, for both the victim's family and the defendant's family. Does the state have any input on when you would like the pretrial?
Just as soon as practical, Your Honor. But we do have one issue we'd like to take up with the court.
Okay.
We agree that we'd like this to be expedient. One of the issues that we are concerned with is sometime down the road something might happen. So up front and early on, I think a couple things need to be addressed, and the defendant needs to be made aware and waive any potential conflict or any potential problems. It came to our attention via actually a news article we read where Ms. Clifton had posted a Facebook posting where she indicated that she was not qualified. Now, I know she has two individuals that are helping her on this case, but I believe the defendant needs to be made aware of those comments and waive any potential issue that he might have, because at some point in time she might handle some of these issues or some of the parts of the case. And when she went on social media and indicated she was not qualified, and I've got a copy of that Facebook posting if the court wants to see it, I just think that in an abundance of caution, the defendant needs to be made aware of those statements and waive any potential conflict. We don't want to go through a whole prosecution on this case and later be faced with post-conviction relief issues that deal with these issues. The second issue that we'd like to address with the court, and I think, again, the defendant can waive it. That's fine. I have no problem with that. But Mr. Camarino appeared on a radio show, a 25-minute interview on FM 94.1 Wild, where he voiced his opinions about this case, voiced his opinions which were that the defendant did not act appropriately. And I'll just say that, and that's kind of kind. So I think that his statements during that 25-minute interview are important, that Mr. Drejka be aware of those positions that he had previously taken on that radio show and waive any potential conflicts. And I only do that because, again, I don't want, after the case is closed, if we result in a conviction, I don't want someone coming forward and using that as a reason for an incompetency of counsel or that the defendant should have been apprised of this situation. I have a copy of that radio that I can give to the defense, and they can play it at some point in time, and we can come back, and on the record, the court can ask him if the defendant has listened to it and if he waives any potential conflicts because of those comments by one of his defense attorneys.
All right. Can I see a copy of the Facebook page?
Yes.
You have that? All right, so what I'm gathering here is that Ms. Clifton was representing Mr. Drejka, and she was asking for assistance from other lawyers, correct?
I think it might have been she was asking for assistance, not yet representing, but asking for assistance. But again, I can't answer that.
All right, and then obviously we have Mr. Trevino here and Mr. Camarino here, and they have decades of experience in criminal defense work. So I don't know if there's really a potential issue here. She doesn't really say that she's incompetent. She just says that she's asking for assistance for people to...
She says, I sure ain't qualified for this blank show.
All right, what says the defense about that?
Yes. Your Honor, Mr. Drejka is aware of these issues. In fact, Mr. Camerino, with respect to the issue of the radio interview, has voluntarily disclosed that to Mr. Drejka and discussed with him that he had made some comments, and Mr. Drejka had no problem with that. As far as Ms. Clifton, again, no problem, given that she has sought and been able to get qualified lawyers to assist her. So I don't see an issue, Judge. If you want to make the inquiry, you're certainly welcome to, Your Honor.
All right, so why don't I give this to the defense to show it to Mr. Drejka to make sure that he's seen it?
We have it, Judge.
Okay, you have it, all right. All right, so Mr. Drejka, why don't you go ahead and read that Facebook post. All right, so have you had a chance to read the Facebook post? Yes. All right, and has Mr. Camerino spoke to you about what he may have said in a radio interview? Yes. Have you had a chance to listen to that radio interview? All right, well, it looks like Mr. Schaub is giving Mr. Camerino a CD of it, so you can listen to that. At this point, are you willing to waive or give up any sort of conflict or any sort of issue involving Mr. Camerino and Ms. Clifton?
Yes.
Do you still want those lawyers to represent you in this case? Do you have any issues at all with your lawyers? Are you satisfied with their help and advice so far?
Yes, sir.
The only thing I'd ask, Your Honor, is at some point in time, Mr. Drejka, if he is to listen to this, I'd ask that he does listen to it, and at some point in time, if he has a problem, he can readdress that with the court. If he doesn't readdress it, I'll assume that he has no issue with those statements.
All right. So between now and the next pretrial conference, if you need to get costs from the state, obviously you can set those on Judge Rondolino's calendar. You can get started on the depositions. The defense hasn't received their discovery yet. Is the state going to file a notice of Williams rule on these other incidents?
Yes, Your Honor, we are.
All right, so if you can do that sooner rather than later, and you may even want to put those witnesses in the original witness list, but obviously you have to do a notice of Williams rule and list them so they know who they are, and at some point we may have a hearing on those Williams rule witnesses. So let's try to get this done as efficiently as possible and still give everyone a due process. So let's get started on the depositions and everything. I'm thinking sometime in October for a pretrial. Any particular day of the week that's good or bad for anybody? Doesn't
No, Your
matter.
Honor.
Fridays are usually best for us, Judge.
All right. All right. You want to do it in the afternoon, so you'll be the only ones on the calendar?
That'd be fine.
Yes, sir. All right. So how about October 19 at 1:30? That'll be our pretrial, and you are waiving speedy trial in the arraignment, correct?
That is correct, yes.
All right. All right. Anything else from anybody? All right.
No, Your Honor.
Thank you.
Thank you, Your Honor.
All right. Let's take a 10-minute break, and then we'll finish up with the calendar.
All right. We'll stand in recess. Oh, yeah, I'm back. Yeah, I am.